Renee Lauber is a local government planning specialist in Wisconsin. Her work focuses on policy, strategic communications, land planning use, and farmland protection programs. Notably, she has worked with the town of Dunn and currently works with the town of Dunkirk to help their purchase of development program.
What I thought we would talk about is why protect land, get into that just a little bit, talk about the big picture, what's going on, national, state, local, and then talk a little about PDR, which is purchase of development rights, and how those programs work, and then just open it up for questions. Let's see. Regarding the why, just really quick, I think you guys probably know more about this than I do, but obviously farms feed us. I've been at some meetings where they talk about national security, with everything that happened during the pandemic. Regional food security, having food local is obviously has its importance. In Dane County, agriculture is a huge part of our economy. And then obviously, probably of most interest to you is climate resilience. There's lots of opportunities if land is protected and not developed to capture carbon, whether it's through a prairie or a forested area or other types of things. I know everything has different value. And then there's limiting sprawl. And so I put the limiting sprawl in bold because I want to just talk about that a little bit. I had a conversation with Sharon. There's just to talk a little bit about how sprawl actually happens. And so I just wanted to touch on annexation. I'm not an expert. That could be an entire presentation for you, how annexations work. But cities and villages grow by annexing land from towns. And so a lot of time, I work with towns, and so a lot of times that just sets up not the best relationship. And annexation laws were written, a lot of them were written, when we became a state, and they've been changed since then, but the tenor has always been the same, that they're in favor of growth. And they give pretty close to complete control, in my opinion, to cities and villages to annex land and take that land from towns and bring it into the city or village. And so for some towns, purchasing development rights is one of the few things that they can do to kind of change that dynamic. Because if a city is taking the land, they obviously would like to develop it. I think one of the things that they have to show in the law is that they can provide goods and services better than the town can. That's not too hard to show because cities provide so much more services than towns do, which is why they have a higher tax base. And we could really go down that rabbit hole. But I think those are the three important points to know. And as we go on, I think this annexation thing and how this all fits might have a little bit more clarity. So that's one perspective on why we're protecting farmland. This is all written for farmland because I mostly do purchase of development rights for farmland, but you can do it for wetlands, you can do it for forests, you can do it for prairies. This just has a little bit of a farmland focus because that's my background. And so just a little bit more from the landowner perspective, rather than the big picture climate change perspective. For a lot of farmers or landowners, it's a business decision that they're making. A lot of farmers are land rich and cash poor, and it's a way to get some money out of their land without having to sell it. And in a lot of cases, because the prices are so high, there's a donation component that can be a significant tax deduction. For farmers specifically, there are laws written that you can take the deduction over a much longer time period. I think it's 15 years. And that's written specifically to help that community that's typically low income maximize that donation, or not low income, lower on the income scale, I should say, maximize that donation. It's also used for landowners as a way for estate planning to divide their assets. Say they have two children that they would like to treat equally. If one wants to stay in farming and the other doesn't, one can take some cash and the other can take the land. And it can all be done while the parents are still alive. So those are some of the perspectives that I've had from landowners. I just thought I would share that with you. Other perspectives from the farmland are that it's going to reduce the price of land at the next sale. So it's a way to encourage farmers to get into the business for younger farmers. It gives farmers more cash to reinvest in their operations if that's something that they need. And then some farmers and some people in general are just in it because they want that permanent protection of that farm. They love that land and they don't want to see it developed. And they want to know that. And this is one thing that they can do. What is this? And so also briefly on the big picture, just to give you some context for this, purchasing development rights is it's going on everywhere. This is an old slide from 2016. There's probably a more recent one out there. And it shows different colors of different programs. Local programs might be run by a town or a county, which is the this color green, and then it shows state programs, and then some state and local. So Wisconsin has state and local programs. And then there are some states that don't do this at all. The history of this is that it was really started on the East Coast and maybe some in California, and then it's spread. When I used to be at the town of Dunn and I used to talk about it, there's a lot of federal funding out there, and until the town of Dunn had a program in Wisconsin, that federal funding, which we all pay into our federal tax dollars, was not coming back at all to our state. And so that's just something kind of to keep in mind too. And then funding is a huge part of this. So when we're talking about federal programs, some of the programs are under NRCS, which is USDA. They really focus on high quality soils. And when we're looking at protecting those lands, we're spending a lot of time looking at maps to see if they're, class 1, class 2, class 3, how those soils rate, because there's a lot of funding for those programs, and they're very much based on the soil maps. The other program that I've used is it's called NAWCA, which is a wetlands program. It's through the Fish and Wildlife Service, and that's actually run through Audubon here in Wisconsin, and that's very much for wetland habitat. There's probably other federal programs that I'm not aware of, but those are the two big ones that I work with. And then kind of bringing it home to Wisconsin, the state has programs through the Knowles-Nelson Stewardship Program, and they used to have, before Walker, there were some other programs that maybe could get going again, who knows. So there's definitely statewide money out there for buying conservation easements. And then I just put down the counties that I know of that have programs. Dane County does buy easements. They have a conservation fund, and right now I'm working with them on getting a new program set up. We had $300,000 in it last year, but haven't quite gotten all the criteria yet, and we'll be going to the county board this budget season to ask them to fund at least another 300,000. We're hoping for quite a bit more. And so that's in process right now with Dane County, but they do easements through other programs that are already existing. And then these are just the towns that I know of, and I've worked with Dunn and Dunkirk, and there could be more going on in Wisconsin, but that is what I know about. So I'm going to talk a little bit now how it works. And let's just get some of the terms down. So PDR is a word I use a lot. That's for purchase of development rights. ASAP is another one. It's Agricultural Conservation Easement Program. A lot of these programs are based on agriculture. And then PACE is another one, purchase of agricultural conservation easements. These all mean the same thing in general. Let's see here. What are development rights? So when you own land, you own a whole bunch of rights that go with it. There are ways to separate these rights from the land. And one of the most common ways that we refer to it, a lot of people know that if you go out west, oil and gas rights have been sold. So if you buy property, there's a high likelihood there would be no oil or gas rights associated with it. You would still have all the other rights. So you could have your rights when you own land to rent it, to sell timber, to control access. There's just a lot of rights that come with being a landowner. And what a conservation easement does, or when you buy the development rights, you just separate that. And there's a legal document that says who gets what. You can separate them. And so, like I said, out west, oil and gas rights are held usually by another company. And any of these rights could be on either side of this PowerPoint. And that's all what's in the legal thing. So basically, it's just a legal way of saying which rights are being kept by the landowner and which rights are going to the easement holder. And so here we are with, conservation easement. That term comes up a lot. It's just the legal document that's used to record the permanent land use restrictions. So, and they're usually quite large, these legal documents. They say a lot. And so the basic concept of a purchase of development rights program, is that it's voluntary, and that we buy these development rights from the landowners. And so the landowner is paid to do this, and that's one of the ways that this is thought of as more equitable, because there's a payment involved. And some of the other concepts that are associated with the purchase of development rights is that this is meant to be forever. So it's a perpetual easement that's placed on the property. And I can talk a little bit more about how we try to set this up as forever. And that this land remains in private ownership, which for a lot of towns and things like that means that these properties are still on their tax rolls. And that's very much appreciated. With use value tax in Wisconsin, there's not a lot. Once an easement is placed on a property, there's not a lot of difference at all in the tax revenue that's coming into a town. So for towns, that's a bonus. And the landowner retains all other rights and responsibilities except for what's in that conservation easement document. So they still have the right to pay taxes and all of those other things that are normally associated with the property. And when the property is sold, the easement's on the deed and it goes with the property. So like I said before, I mostly deal with agricultural easements. So this is what's in a typical easement that I would work on. But these can really be crafted to be anything. And so the easements that I do, there are development restrictions. Sometimes it says you can put one more house on the property or two more houses on the property, but it's not left wide open like land is now. Sometimes it says you can split the property into two pieces. Sometimes it says it all has to remain in one piece. It usually limits everything except for the agricultural industry. So anything commercial, industrial, mining, that kind of stuff is restricted. In addition to restrictions, sometimes there's requirements that, and especially with the agricultural easements, that they farm according to NRCS standards and have a plan. As far as there's usually clear cutting restrictions for forested or wooded areas, and if they want to harvest, they have to have a plan. And there's usually wetland protections, impervious surface restrictions. If we're doing something with NRCS, it's a 2% impervious surface restriction. So that total development, if they're putting in a farm road or if they're putting up new buildings, NRCS really wants to see that the soil is not covered. So that's why they put in that 2% restriction. And just really, again, those are the typical things that I'm looking at. NRCS now also really would like to know the location of future buildings on the property. And they usually just draw a square of a couple acres and say this is where it wants to go. Again, they're looking at trying to put buildings on the least productive soils. And so that's where they're coming from when they're doing this. But these are kind of things that you can use if you have other goals in mind. So that's why I'm kind of letting you know some of the things that we do in a typical easement. All easements are not the same. They're negotiated between the parties involved. When I do this work, I'm doing it with towns. So that the town interest, the landowner interest, and then the granting agency's interest are all need to be taken into consideration, and everybody needs to agree. When I say, an example is, will the landowner keep any splits? Splits are the right to divide off a piece to put another house on it. So sometimes the landowner will keep one or two of those, but it's still a huge win if it's a 200-acre farm and they only are left with the rights to put up 2 houses. And then a lot of times there's things written in for natural areas or farmland. As far as valuing easements goes, that's a question that comes up a lot. How do we put a price tag on this? And that is done with an appraisal that usually in this case, the town hires an appraiser. And I was told that this slide was confusing at one of my last, asked for a new slide. So here is this. So for example, on a 100-acre farm, when you hire a appraiser, I call it total development value, but in appraisal language, it's called highest and best use, which means if that land was going to be developed. So if that land is right next to Stoughton, and the appraiser seems to think that there's a chance that that could be annexed by Stoughton, they're going to put that value in. If that land is further away, 5 miles away from any development, the highest and best use is going to be different. And so that is a call that the appraiser makes on what the total development value of that property is. And then once you put the conservation easement, once you restrict it, they can still sell the land. So that would be the after value. After this legal restrictions are put on the property, what is it going to be worth? So the appraiser might come in and say, if you sold that land today, a developer would pay $1 million for it. If you put this conservation easement on it, you're only going to be able to sell it for $640,000. So then the value that we're paying is that difference, which is that $360,000. And so that's done, and that's a grant requirement. You can't do any of this without, even if it's a donation, without an appraisal. That's kind of the nuts and bolts of how this is done. Just gonna check my time here. And so just a couple other things to know about buying development rights, and this gets into what I was talking about before about how do we make this permanent. When we work in Dunkirk and in the town of Dunn and other places, we partner. And we partner with Groundswell, which is a land trust. I don't know if you know a lot about the land trust community, but they're huge. Groundswell is just excellent. And they are a co-holder of the easement. And when I used to work in the town of Dunn, the town chair, Ed Minahan, would say that, zoning and land protection and some of these things are only as good as the next election. And in a town board where you have 3 people, you could see how it wouldn't take that much for everything to change in a town. And so if they're the only people that are keeping this conservation easement, and they're the only people that are enforcing it, that's foreseen as a problem. And so we partner with Groundswell so that there will be no amendments to the easement without both partners saying yes. So to amend an easement, you would need Groundswell, you would need the town, and you would need the landowner. And so since Groundswell is involved, we think that's much less likely because their mission is to uphold these easements. We also try to get every single layer of additional anything that we can. And a lot of times that comes in all of these other programs that I told you about. So that comes from the federal, if we can get a federal grant, that's seen as golden, because when it comes to eminent domain and things like that, that are ways that cities and villages grow. Sometimes they can annex the land. There's eminent domain where they can take the land. The federal government really trumps that because they have stated a use. They have stated that this is what this property is for, and so Stoughton could not come in and claim eminent domain on something that had a federal easement on it. If it was just protected by the town, there's hasn't been a test, but we think that something like that could happen. So we're always trying to get the county, the state, or the federal government involved, even if it's just for a little bit of money. We see that as a huge layer of protection in getting to this, what we want to be perpetual or forever for these easements. Another thing that Groundswell does for us is it buys insurance through, I think it's called Terra Firma, so that if there's ever a legal fight, if someone comes up and seems to think that, well, I've got deep pockets, I can do whatever I want, these towns can't afford a big lawsuit. We have that insurance, and we also give an endowment. For each deal that we do, we give $10,000 to Groundswell. And that endowment is growing so that they have a legal fund and so that they can come out every year and do monitoring. Sometimes it's just drive by. You can tell that no new houses or buildings were put up. There's really nothing to see. It takes 5 minutes. Sometimes they go and walk through the property, but they're keeping an eye on things. And they're that kind of group that we expect to be around for a very long time. So that's the nonprofit and how we're trying to layer things to make this last forever. And then kind of finally, this is just the checklist of that I show at some town meetings of why this is good for landowners. We talked about how it's voluntary, how they're compensated, and how it's an alternative. I talk about it a lot as it gives them choice. Sometimes if someone's trying to sell their properties and they want to get the most that they can get for their property because they need that, selling to a developer is their only choice. And now we come in and are hopefully giving them another choice of a way to get some value out of their property. There's also a lot of studies that we could go into on the need for public services. A lot of times people say that cows don't call 911 or go to school. So for towns and for those kind of things, they can help keep a rural areas taxes down for those things. And we already talked about some of these others. For residents, it's protecting their land, their open space, their rural character, things like that. I can tell you that, we had a campaign in Dunkirk, and right before the pandemic, they had a referendum on whether or not to raise their taxes to pay for this program, and it passed by 62%, which in, politics in this day and age is kind of like a landslide. So we were very happy with that, and that's what kind of kicked off the program that I'm working on with them. What are the downsides? Because there's downsides. This is time consuming. It could easily take 2 years to do a deal. Most of it is because of the agencies that we're dealing with and getting the grant money. If someone wasn't interested in the money and just wanted to work with a local government and do a donation. It still takes a bit of time, but they're not quick. They require future monitoring and enforcement that we talked about. And they can be expensive. And a lot of people think that this really only works well when you can kind of get a critical mass or large blocks of land. And I think I told you that I worked before with the town of Dunn. This is the map from there. And they're starting to get, so the yellow outline is the town. You can see here how McFarland is, when they grow, they're taking land from the town of Dunn. And the blue is the land that's in private conservation that they bought with their purchase of development rights program. And then they have, other entities that they are very supportive of in getting town land. So I'm showing you this to see that, you start someplace and then you can build and get those critical masses. And then I wouldn't be doing my job if I didn't tell you that there's also another way that these development rights are kind of done, and that's with a transfer of development rights program. And a lot of towns have transfer policies. This is a link to Dane County's website where they talk about transfer of development rights. Probably, I don't know, 5-10 years ago, the county passed an ordinance amendment that creates this in Dane County as a way to transfer. Some of these towns that transfer just transfer 1-to-1. So I've got one, I can transfer one over here, one house. Some of them have these programs that are trying to be incentives where if you transfer one in this area where we really want, you'll get 5 over here. But it's a little bit more complicated, and it's another presentation basically. And basically, if you're purchasing a development right, you're just removing it. It goes away. That house goes away. If you transfer a development right, you might take 1 or 2 or 3 houses and move them someplace where it would be better, and then protect the rest of the land from being developed. The transfers are market-based. It's a whole huge thing. So I just kind of wanted to bring it up to let you know that it's out there and not really get into it that much, but those are called TDR programs. And if you're interested in that, like I said, a whole nother thing.
Thank you so much for watching this video, and we want to thank you for your support for a greener future. And please continue to support 350 Wisconsin by visiting our website.